The question is that the motion be agreed to. The Honourable David Park.
Thank you, Mr Speaker. I rise to support the third reading. Could I just deal with the point that the Honourable Jerry Brownlee referred to just before he sat down again, which was the attempts by Labor and other parties to knock out the clause 13 and a related clause later that the Greens picked up. I think it was clause 22. The effect of those clauses is to say that if even if someone's adversely affected by something that's being done in breach of this, they haven't got a private remedy. And the point I thought that there was actually some sympathy for from some National Party members on the committee as well is you can envisage a situation, for example, up the Clarence River, where a river's been diverted, and someone, it might now be flowing across their land, and they might think, oh, well, I've got the right here to divert the river, and they could be causing considerable harm to someone else, and the council might say, oh, well, it's happened now, and they might not do anything about it. Well, that person's got no remedy forever under this. They've actually got to convince the council that they should do something rather than actually having a right to do it themselves, even if though they might be suffering that adverse impact. And I thought that was unnecessary. It wasn't going to stop anything being done. It was just going to stop it. No, it wouldn't have stopped anything being done, because this is only an enforcement proceeding that happens after things have been done in practice. It doesn't stop them doing it. It doesn't put them at risk for having done so. It would have just said that if they'd gone too far or if there was an adverse effect on someone else eventually, that could be addressed. Anyway, sir, that's a detail. This is a good bill. In respect of the other matter of substance, which is, I don't think the change that's being made in respect of the powers of councils and utility operators is substantial at all. It just changes the period that they've got to give notice of what they do rather than changes what they can do. The third leg of the bill, or third leg of the stool, is the rehabilitation of Kaikōura Harbour. I agree that is a substantial change to the provisions of the RMA that would otherwise apply. I think it is necessary. I think we need to get on and start doing the excavation or the dredging that's necessary to make that port accessible, in part to get the industry going again, the tourism industry and the fishing industry. I think the mix of people that are required to be involved, which are listed out in clause 19.2, is already quite an extensive list. I personally would have been happy for them to invite written comments from anyone else. I don't think that would have been too onerous for the consent authority to hear what other people thought, but the government said they don't want to go that broad, and that's fair enough. I can understand that. I think the group that are left being asked to provide written comments is quite broad. It includes Ngāi Tahu and the relevant Papatipu Runanga, the various councils, the Kaikōura Coastal Marine Guardians, the Maritime New Zealand, various ministers, Canterbury Regional Council. All of these people, or a lot of these people, are democratically elected representatives of their local people anyway, and so you can, I would have thought, rely upon them to take a pretty balanced interest. So, sir, I'm very happy to support this bill in its third reading.